Greetings and salutations, my fellow sovereigns. This is the Vocational Science of Freedom Saturday Night Civics and Sovereignty class. And this was the first Civics and Sovereignty class for the year of 2023. Tonight we're going to be covering a handout which I just created for someone in the VSOF regarding what your options are as far as when you get a traffic ticket. The link for the document is in chat on Gilded. And if you'd like to join our Vocational Science Freedom Gilded server, you can do so by going to the Vocational Science Freedom YouTube page. And the link is in the upper right-hand corner of the banner. And also the link is in every single class show notes for every single class, both on Odysee and on YouTube. So with that, let's open up the document. And what I'd like to do tonight is allow everyone to give me their feedback at the end of this. So this is not a complete and total list of everything that you could do after a traffic ticket, but it contains the vast majority of the options that are most available to most people. And what I mean by that is that this document is going to be mostly based upon what you can do in court, either in a court of record at law or in defense in a Roman civil law court of equity, which is statutes, acts, ordinances, and codes. So with that, I'm just going to start reading this, and then you guys can, I'll stop and start and ask for options or ideas, or you can also always just put your options and ideas into chat as we just run along here. Okay. So as I said, let's open this up. This is the document, VSOF Learning Handout number 1, Options and Plan of Attack After a Traffic Ticket 1.0. So your options and plan of attack after you get a traffic ticket. There are only 2 different statuses that matter in this situation. And when you get pulled over, you are stuck with one of them. You have at that exact time and point. Because you can't alter your status and have something work retroactively, in a sense. And there's rules in law for that. One that's, and this isn't exactly on point, but it's to make an analogy here, is something like an ex post facto law. You can't create a law and then turn around and then criminalize people for something that they did yesterday when that law didn't exist yesterday. Well, it works kind of the same way regarding status as well. If you have a particular status that you have, well, then that's what you have at the time. And they're going to treat you, even if you, well, all right, I'll get into the changing of status in a second. But the point is that most everyone is going to be a citizen of the United States, meaning a 14th Amendment citizen. So the 2 different statuses are either one, you are an American citizen, capital C citizen, of one of the several states of the Union. Now, this would mean that you are already or should already be on the NCIC Do Not Detain, Do Not Arrest list. And you should never have been pulled over in the first place, because that database, the NCIC, is the National Crime Database. And they have everybody's information who is not a citizen of the United States, meaning that they've already altered their status and corrected it. And the reason that we can do this, the reason why it's lawful, and of course, I've done plenty of other classes on this, which you can take a look at and listen to on Odysee and on YouTube. But the point is that under the Expatriation Act, it clearly delineates 2 complete and separate different statuses, different types of citizenship, which are the 2 listed that I have here in the handout. So either one, you're an American citizen of one of the people of the states of the Union. This would be the people. This would be you as one of the people in your sovereign capacity. And then number 2 is the second class of citizenship, literally and figuratively, that you're a 14th Amendment citizen, lowercase c citizen of the United States and a resident of somewhere that is subject to the jurisdiction of Congress. And that you yourself are also subject to the jurisdiction of Congress as well. And that's something you can read in the 14th Amendment, because a citizen of the United States is born or naturalized in the United States and subject to the jurisdiction of Congress. Okay, so if you're born or naturalized but not subject to the jurisdiction of Congress, well, then you're not a 14th Amendment citizen. And so what this means is that you're an infant, that you're using property that is registered with the corporate state of evil and are subject to Roman civil law rules, meaning statutes, acts, ordinances, and codes, that they enforce upon you within and from you agreeing to be a party to various adhesion contracts called licenses or pledges that were made by your mother at the Foundling Hospital by document. Now, that's the original pledge, of course, because we're all pledged as foundlings, and a foundling is a lost or abandoned child of unknown parentage. You're abandoned by document at the Foundling Hospital, and then the state, the corporate state, ends up administering your estate, which is everything that you own in law, basically from cradle to grave, because we never come back to claim it. But that's, of course, what's fixed with and corrected on the public record by the Vocational Science of Freedom status doc set. But these are the two different statuses. So when you get pulled over, you're either going to be one of these two. And the only other thing that you could possibly be would be someone who's actually a citizen of literally some other country. But that's not really what we're going to be talking about right now. We're just going to be focusing on these two, which one you are and what you need to do afterwards. So after that, from the standpoint that there are only two statuses, so you're going to be one or the other, then I wrote down here, and this, like I said, this is not a complete and exhaustive list. There are other things that can be done after you get a traffic ticket. But these 4 paths that I put down here are going to be specific to what you can do with court or in certain courts. Okay, so just keep that in mind. So I left things out of this handout, like taking a much higher position in law, as in convening a grand jury of 25 members of the peerage, or writing out a high prerogative writ to the state Supreme Court, meaning something like mandamus or quo warranto or habeas corpus if someone actually happened to be jailed for a traffic ticket and they're holding the body. What we're talking about here more or less kind of excludes those things, even though I did kind of put it under common law, one of the common law attacks. But the grand jury part is not in here, so just be aware of that, which I can add later, because like I said, I just put this together for Viper about 2 days ago, because he was asking me about, okay, what do I just got a traffic ticket, so what do I do? So I said, okay, fine, I'll write this up and create it, but this will be an ongoing expanded document. So we'll keep working on this together as a community and growing it out. So, okay, so to start here. So there are 4 paths which you can take when your estate is charged with a traffic fine. And that's exactly what they're doing, by the way. They're charging your estate. They're not charging you. They're charging your estate, because your estate is the thing that is out here being abandoned. And then what they do is they create a constructive trust, which is the court case, to then take the res, R-E-S, which is the stuff of the estate, and put it into a trust of which then they can administer. Okay. So you must pick and choose one of these options you wish to take. You can take more than one option here. However, in doing so, you will make more work for yourself, and potentially you will get confused as to exactly what you need to do between these options, because obviously writing things at law is an entirely different situation and process than writing things in an equity court following civil rules of procedure under the state rules, under the state court rules. So, but anyway, so I'm just going to go over these real quick and kind of show you what they are, and then I'll come back and read them. So we have 1, common law attack, 2, common law defenses, 3, Roman civil law attacks, and 4, Roman civil law defenses, because there are only 2 origins of law, period, full stop. They are common law and statute, and statutes are Roman civil law. And I put a little snippet of a introduction of a law treatise. I can't remember which one it was, but I snipped it out and threw it in here because I wanted to read this really short, so people who have no idea what we're talking about can at least understand the difference between Roman civil law and the common law. Okay, so introduction. As I said, I don't remember which treatise this was from, but I'm just going to read it. There have grown up in the history of nations only 2 great systems of law: the civil law of ancient Rome and the common law of England. all the most civilized nations in the world are governed by either the one or the other of these two great schemes of justice. Though the civil law and the common law have much in common, yet in many important particulars, they are the opposites of each other. Okay, and that's something extremely important. And remember, this is coming directly out of a law treatise. So the treatises on law you can use as authority in court if you need to. But I'm just going to read that again. So, though the civil law and common law have much in common, yet in many important particulars, they are the opposites of each other. In the course of his studies, the student of law finds so much said in an incidental way about the civil law that is calculated to mislead his judgment in regard to the true character of that scheme of justice. That it is important on the outset of his walks over the field of the common law to give him some account of the civil law and point out in what it differs essentially from the common law. This is a matter of much importance to every student who aspires to a comprehensive and enlightened knowledge of jurisprudence. So, just remember that yes, there are some similarities between the two systems. However, as it said, they are basically the opposites of each other. And to give a good point of that, the aspect of Roman civil law is you're basically guilty until you prove yourself innocent. And under the common law, you're innocent until you're proven guilty. That's one of the basic opposites between these two systems of law. So with that in mind, let's now go through each one of these. Okay, so you're going down the road, you're traveling down the road, you're in your conveyance, you're not engaged in commerce on the roads and highways, which means you're not for hire. I mean, there's nobody sitting in the passenger seat who's paying you to take them from point A to point B. You're not having a semi-load of goods that you are transporting from New York to Texas for some reason, and somebody's not paying you to do that. So those two things are either a for-hire carrier or a contract carrier. So you're not doing either one of those two things. So you're not engaged in commerce on the roads and highways. You are simply exercising your inalienable right to travel from point A to point B, which is your common law right in America, because we the people own the roads. Now, there might be some ignorant land pirates out there that would attempt to argue that point, but they would be 100% absolutely incorrect. We the people own the roads. And I'll make 2 points about this. One, if you go to and look up the land patents, the original land patents for basically all the land that's out here, you're going to find that land, the original land patents, meet up with your neighbor's land patent, mostly where? In the middle of the road that's between both of your allodial lands. Okay, now what does that mean? It means that you, on, say, the south side of the road, are giving your fellow people, your fellow sovereigns, an easement along the land which belongs to you that road sits on. You are giving them an easement to travel from point A to point B, and you're not taxing them or tolling them for traveling upon your land. Okay? And so is the neighbor to the north of the road doing the same thing. But if you look at the land patents, they all meet in the middle of the road. Now, the only exception of this is where the United States federal government has actually bought the land back. That would be your interstate highway system. Okay? And it's very important to understand and realize in history that when they came along with all these statutes, acts, ordinances, and codes, and all of the DOT bullshit, and all of your going to the DMV, the Department of Motor Vehicles in the States, all of these rules and regulations came along right when the interstate highway system got put up. Now, this was during Eisenhower's time. All right? And what people need to realize about this is that it was a total power grab from the corporate state, from DC, where they wanted to entrap everyone. Now, technically, when you are on the interstates, you are on government property. So, in a sense, there are different arguments to be had here when you are on the interstate and when you are not. But I'm not trying to get into that level of minutia. But I just want everybody to be aware of it, of where this whole system came from and where we have kind of lost, or I don't say given up or abandoned, but we have certainly neglected to exercise our rights properly under common law on our own roads and highways, and take to task all of these land pirates that are out here basically stealing money from you. It's a racketeering. It's the totality of what they're doing is a racketeering organization. That's it. That's all they're doing. And it's based behind the attorneys, and they're out here collecting money for what? For municipalities, which are corporate creatures, which are appearing as though they're actually some sort of de jure government, when in truth, in fact, they're simply just municipal corporations, like the county of Dane or the city of New York or even the state of Wisconsin, all capital letters. All of these things are corporate municipalities. They're under Roman civil law, and everything that they write out and create are aspects of public policy. Public policy exists to administer infants. Public law is different. Public law means that there's some sort of harm, and public law applies to everyone. So just remember those different distinctions as well as we're going through this. Okay. So common law attacks. So one option is you be the plaintiff in a court of record at law, meaning the common law. So examples of common law attacks would be as follows. A countersuit at law, where you are the counter plaintiff and file an action at law for trespass and trespass on the case, for common law theft, inland piracy, kidnapping, and if they arrested you, put you in jail, meaning the kidnapping, and any other counts you want to come up with. Now, again, to understand this, well, you know what? I'm just going to read the rest of this and I'll get down to the how you learn how to do this, because I'm not going to try and teach a whole course here on how to specifically file an action at law. That's not what I want to do here. I just want to give the options. Okay, so that's one. So another example would be a writ of mandamus demanding that they explain what gives them the right to attack you on the roads and highways and deprive you of your substantive rights. A writ of mandamus would be something that would be filed. It's a high prerogative writ, and it has original jurisdiction in the state Supreme Court. Number three, another high prerogative writ would be a writ of habeas corpus. Now, you want to, in a court of record, meaning at law, when you do a habeas corpus, you do not want to file a statutory habeas corpus. They go nowhere. They do nothing except maybe make you feel better, but it won't accomplish anything. Because there's a huge difference between a statutory-based habeas corpus and a common law-based habeas corpus. And the difference is that common law is a higher form of law, and that any sort of statutory-based habeas corpus is always going to be adjudicated in an equity court, basically a chancery court. And that's where the chancellor sits up there and determines whatever he wants to based upon his own conscience. Well, guess what? That's never going to work out in your favor, because no black robe priest of El being the god of Saturn, also the god of banking and lies, no priest of El sitting up there acting as a chancellor is ever going to rule in your favor. Ever. Period. Their whole purpose is to take everything they possibly can from you. But a writ of habeas corpus at common law is a different matter, because you have the right to a writ of habeas corpus, and you have a right to a common law writ of habeas corpus, meaning one that does not follow statutes, acts, ordinances, and codes, which is what happens in a court of record. Courts of record at law do not follow statutes, acts, ordinances, and codes. They follow the common law, which is an entirely different rule set. But again, as I said, I'm not trying to teach a whole course on how to do an action at law. I just want to make that point. Okay, so a writ of habeas corpus demanding that the state produce the damaged party to your superior court of record. And if they can't, to dismiss their inferior court case in your superior court of record. And like I said, again, this is only basically when you're in jail. But you can do it even if you are out of jail, because if you, and this is another thing about traffic tickets, if they pot you and they stick you in a jail cell and they force you to sign a bond to get out, always make sure that you sign that bond under duress. Okay. And this is one of the times where you do want to put things like without prejudice, and you can, if you want to, use the UCC codes, but it's all that you have to do to simply write down on the document right above your signature under duress. Another way, if you want to be clever about it, or if they get pissy and say you can't sign it like that, well, another thing you can do is you can put a capital V period, capital C period, and that stands for V coacutus in Latin, which also means under duress. So if you can put the abbreviation there, they're going to be too stupid to understand what the Latin means anyway. Plus, it's abbreviation, so it kind of looks like part of your name, sort of, but there'll be a lot less possibility of them balking about it if you put down VC compared to signing it flat out under duress. But that is definitely the stronger way to do it. Okay, so anyway, so since you signed the bond under duress, part of your estate is still being held captive by them by document. So in a sense, demanding and writing out a common law writ of habeas corpus that the state produce a damaged party at law to your superior court of record is still a valid process, even if you're not in jail. So just to make that point. Okay, and then each one of these different options here is going to have an A, a B, and a C. Okay, and the B is going to be your resource options for gathering information for this particular path. So for common law attack, the vocational science of freedom court of record templates for courts of record actions, which are all for so anybody who's a VSOF member has access to all of that in the VSOF online members library. If you're a lifetime member, you already have my hard drive and you already have all of them anyway. So anyway, those are the two ways of getting at those. The VSOF ins and outs of court class, that's a class that's on YouTube and on Odysee. I highly suggest that people watch that to understand how to operate your court and what is a court and what is a motion and how do you present a motion and all that good stuff. And then also the Vocational Science of Freedom Totality of Law class. That's a class where I teach the different jurisdictions of law, kind of like the little introductory thing that we had here with the common law and civil law, the common law and the Roman civil law here in the beginning. And in the totality of law class, I teach all the different forms of law. And it's important, not so much for just worrying about the common law attack, but it is important to understand the differences in the different kinds of jurisdictions. And there's only 5 jurisdictions of law in American jurisprudence, and I might as well state them, even though just tonight we're talking about common law and Roman civil law. You have common law, you have equity, which is basically Roman civil law. You have military, so that only applies if you're actually a member of the military or if you've perhaps committed treason against the country. And there's a lot of hubbub over the last 2 years regarding how many sealed indictments there are. And supposedly there's talk of these sealed indictments being military tribunal type indictments for treason. I would love to see that happen. But so anyway, that's the point, that there's a military jurisdiction. And so those things apply only then. There's an ecclesiastical jurisdiction, which deals with the church, which also is an aspect of probate, even though they don't technically in American jurisprudence talk about ecclesiastical law controlling probate. That is historically where it stems from, and also why you have a black robe priest of El sitting up on the bench dealing with the property of the dead. And then the 5th one is maritime admiralty law, and that deals with all banking and merchant affairs. That also has to deal with everything regarding the law merchant. Okay, so those are basically the 5 different jurisdictions, the 5 different jurisdictions of American jurisprudence and nothing else. They're like, we don't have Sharia law here, right? So those are the only 5 that we have. So, all right. So that's basically a lot of what I teach in the totality of law class, but there's other aspects that you need to understand because of when you are in these different jurisdictions. You have to state certain things differently, write certain things down differently, present things differently, so on and so forth. Okay, so other resources under B. Maxims of law. Because you got to remember that all maxims of law are an aspect of the common law, even if they are maxims that may look like they're kind of dealing with the law merchant. Like, to give an example, would be caveat emptor, right? Buyer beware. That's a Roman civil law maxim. And yes, it's based in the aspect of equity, meaning you don't want to let anybody, take advantage of you. And beware, meaning check your contracts, read what things say, inspect the item before you buy it, things like that, right? These things that seem like they're only law merchant maxims still are held as maxims at law as well, regardless of what jurisdiction they're kind of based off of. So maxims of law are definitely something that you can always use as your authority in any common law suit or motion or anything else that you do at law. Okay, and then treatises on common law procedure, especially ones that contain forms within them. And there is a treatise folder on the Vocational Science of Freedom online library, and anyone who purchases my entire hard drive has my entire treatise folder, which is not on the members library, but it is included when you buy my hard drive. And I have spent more time collecting and searching for treatises on law than anything else that I look for. And the reason is because a treatise is what a thing is, meaning a treatise is a book that describes something. So if you have the treatise on common law procedure, then you have the book, the canonical text, if you will, of what that thing is. If you have a treatise on equity procedure, then you have the book of everything that you should be able to look into, and everything should be included in there that has anything to do with equity procedure. All of it. Because a lot of these treatises are enormous. Some of them are 1,600 pages or more. Some of them, there's multiple volumes of them. So you might have 4 or 5 or 6 of these books at tallying, 1,600 pages each. But the reason you want to collect them and the reason you want to use them is because you can use them like an encyclopedia. You can go, look up what you need to find, learn it, figure out what it is, put it back down, and then go pick up the next one. And so in the collection of treatises, there's nothing more important to collect than treatises and using them. Okay, so to continue here with under common law, tax your resources. Court holdings that predate 1900, because the common law started to get destroyed and weeded out in the early 1900s, particularly when they brought in their filthy central bank in 1913. And then they completely did everything they could to eviscerate it by and after 1933, which was the whole New Deal. So if you're going to do a common law attack at law in a court of record, you're going to want to look for holdings that predate 1900. And yes, some would say, well, they're not valid if they're not old. Yes, they are. Because the common law decisions cannot be altered or diminished or changed or obliterated or coerced is the wrong word, manipulated by anything that Roman civil law does. Because when a court of record decides something, it's final. Like full stop, period, done. It's done. And the Supreme Court has even clearly said this in other holdings. They said that a decision of a court of record is as final on is as final on all the world as a decision of this court would be, meaning that they're talking about the Supreme Court. It puts an end, I might be butchering this quote a little bit, but I believe it says it puts an end regarding the facts by deciding it. Okay, so once a court of record decides something, that's it, it's over. And the question would be, well, why is that? It's because a court of record is the court of the sovereign, where Roman civil law courts, district courts, any other inferior court, a chancery court, like I said, district courts, these all, and even the appellate courts that deal with that system, are all inferior to courts of record. So just remember that. Okay, so these are your resources. And then all of the foundational documents of the Republic, meaning your state constitution, federal constitution, Bill of Rights, so on and so forth, and everything that's listed on 1215.org, which is a site of Bill Thornton that is dedicated to the study of common law and how to proceed. Okay, and then C, preparation and study time required. At least 3 months of learning for the average man or woman with a job. At least 1 month of learning if this is all you do for that month. Now, the first time, now this is me thinking all the way back to my 20s, the first time I ever prepared and got serious about filing motions and going into court for a traffic ticket was in my mid-20s, probably 23, 24, something like that. And it took me an entire month. I did absolutely nothing every single day for an entire month, but putting that courtwork together, learning procedure. I studied the jurisdictionary course, which is something I highly suggest that everybody buy. And there's a link later in the document to go and purchase it. But jurisdictionary will teach you, I want to say everything, but almost everything you would ever want to know and learn about as far as procedure is concerned in Roman civil law courts, in equity courts. Okay. Things that proceed according to statute, act, ordinances, and code. But it's a really, really good course. However, it will take you a whole month to go through it. But do it. It's worth the whatever Dr. Greaves asks for it. I think he asks something like $275. It might be a little bit more now. And you have the course for the rest of your life. You can listen to the audios in your car. You can pull up. He has really great handouts, also like what we do here at VSOF. In fact, I got some of the ideas about how to teach law from him. And it's just a really great course, and it's really important to get it. And it'll take you a whole month to go through it. Okay. So, all right. Number 2, common law defenses. So bring up common law defenses that are predicated on your substantive rights protected by the state and federal constitution. So some examples of common law defenses would be as follows. A plea and abatement, wherein you demand to know exactly who or what it is that they are charging with the crime, because they're not charging you. And there is a Vocational Science of Freedom lifetime member whose name is Blue Star, who is in the Midwest, and he did a plea and abatement and eventually got the prosecuting attorney, the district attorney, to admit in open court that the defendant was a constructive trust. Okay. Now, that was fairly interesting, but yes, we have it, and it's in transcripts, and yeah, he said that. Because Blue Star was making such a point to say, look, I can't possibly put together a defense if I don't know the nature and the cause of the charges that are being brought. And that's part and parcel of your common law right to know that. It's a constitutionally protected right to know the nature and cause of what's coming against you. Okay. If I don't even know what you're charging, then how can I possibly create a defense? And that's the point of a plea and abatement. And by the way, a plea and abatement is something which is called a preliminary plea. So when you do a plea and abatement, you are not actually agreeing to the jurisdiction of the court. Now, do you want to state that, yes, you're making a special appearance? Okay, fine. Yes, of course you can do that. However, the point is that a preliminary plea never grants the court jurisdiction by waiving any argument that could have been made to jurisdiction by simply wandering in there, which is what's called making a general appearance. If you make a general appearance, you've agreed to the jurisdiction of the court. You've agreed that whatever jurisdiction they're running everything under, that you are agreeing to be subject to. And in most cases, that's going to be Roman civil law, equity, inferior court bullshit. But if you make a general appearance without specifically arguing either a plea and abatement as to who or what the hell the damn thing is that they're charging, and or also motions to dismiss on grounds of lack of jurisdiction, whether that be subject matter, venue, or in personam jurisdiction, that you also should always file those as special appearances and never make a general appearance. What you're doing is you're always just challenging the jurisdiction and saying you don't have it. Okay? So plea and abatement's an example of that. Okay, so I'll just continue reading. For we all know that it is not the living man, but a constructive trust that derives its res from your estate. Challenge the jurisdiction of the court on common law grounds, meaning, i.e., no damage party, there's no indictment of a grand jury, the officer that works for the state cannot be a witness for the state. Yes, that's a good point, Spectre. A maxim of law is that a court cannot determine its own jurisdiction. That's absolutely correct. And so when you're challenging the jurisdiction and challenging all the rest of these things, the other party has to prove it because you're putting the burden of proof back on them. And if the state doesn't prove it, well, then they don't have it. All right, to continue here. You were not operating in commerce at the time when you were exercising your right to travel on the roads and highways that belong to the people, of which you are one, which I stated earlier. Okay, so that's some examples of common law defenses. So these are defenses now, not the attacks from the standpoint of suing them and being a counter plaintiff. Some of the things that I didn't add in here, which I probably should, coming to think of it. But again, these are examples. So the other thing that I wanted to mention about this document is that this is it's almost like the preliminary table of contents, if you will. And then what I'm going to do down at the end or later is I'm going to actually go through and then restart and give all of the options of a common law attack and all of the options of a common law defense. So these things are just basically, like I said, kind of like a table of contents that I wanted to write down and give to Viper so that he'd have at least a good document in front of him so that he could state, okay, these are my options. Okay, now I got to figure out which, where I want to go here. So, and that's basically what this whole thing is. But I want to eventually finish it out so that it does contain all of the options, which might take a while, but that's what I want to do with it. So not everything is included in here. So just to make a point of that. Okay, so your resources and options for gathering information on this path are the VSOF Court of Record templates for pleas and abatement, which we have, which is also what Blue Star used in his court case. Demur on other common law defenses. Okay, and I got to explain what a demur is. So a demur is where you agree to all the facts, but you don't agree to the law. So you say, yeah, I did that, but the law doesn't apply to me. We have examples of demurs from various different places around the country, which have worked, of which the district attorney actually dropped the case. And he said, okay, nope, not going there, because they didn't want to bring up those types of arguments. And those types of arguments go directly to the 9th and 10th Amendment, saying, hey, look, I have the right to do this under the 10th Amendment because all rights not, given to yada, yada, are reserved to the states or the people, right? Right. Well, the people are us, and we have the right to hold those rest of those rights not enumerated or specifically granted to, or I should say vested, to the federal government and the state governments. They're reserved. They're reserved to us. So a demur basically says, hey, yeah, I was driving 75 miles an hour in a 55, but your law doesn't apply to me because guess what? I'm exercising my right to travel, and there's no limit or speed limit when I'm exercising that right. If I were engaged in commerce on the roads and highways, that'd be a different story. Then I would be driving, because driving under the United States Code which are the definitions that every single state has to use, by the way, for all of their traffic laws. They all stem from the United States Code. The word driver means unemployed. So you say, yeah, I was going 70 miles an hour down the road, but I was traveling. I wasn't driving at 75 miles an hour. I was traveling at 75 miles an hour in 55. Who cares? The law doesn't apply to me because I was exercising a substantive and protected right, which is protected under the 10th Amendment. So that's basically what a demur is. So I'll give you an idea of that. So a demur, once again, is where you agree to the facts, but you say the law doesn't apply to me. Okay. All right, next one. The VSOF Online Members Library, as before. VSOF Ins and Outs of Court class, as before. The VSOF Totality of Law class, as before. Treatises on law, procedure, especially ones that contain forms within. Again, there are whole treatises. There are whole entire treatises on law just on abatement, just on doing demurs. Okay, that's how specific treatises can get. And those are the ones that you want if that's what you want to do. Court holdings, again, that predate 1900 regarding due process violations, maxims of law, and all the foundational documents of the Republic. Preparation study time required. Actually, I needed to make that there. Now that's right. Okay. At least 2 months of learning for the average man or woman with a job. At least 3 weeks of learning if this is all you do for that time. I should say time, not month, because it's not a full month. And this is the only one that's a little bit less time. And the only reason I state that is because if you wanted to just do a plea and abatement and a demur, it wouldn't take that long to put those two things together and then put it into the court and then demand that they answer. However, if that's all you do, you're probably not going to get the case dismissed. Now, I'm not saying that you're not ever going to get the case dismissed, because obviously we are using templates that worked. I'm just saying is that you should prepare more than just this, than just a plea and abatement and a demur. It's just good tactics. Okay, so that's common law defenses in a nutshell. So now Roman civil law attack. So this is where you're the plaintiff in an inferior court not of record in equity using their statutes, acts, ordinances, and codes. An example of this would be a deprivation of rights under color of lawsuit in federal court and under the federal rules of civil procedure, right? B, your resources, options for gathering information on this path are the VSOF Online Members Library, Ins and Outs of Court, Totality of Law, the federal rules of civil procedure, which is something that I highly suggest everyone read. It's not all that long. It's only, I think, 160, 180 pages, something like that. It's very easy to read. It's very easy to follow. It's very clear and concise. And so if you did want to do if you wanted to make it a federal issue and do a deprivation of rights under color of law, you can do that. There are people that have done it. There are people that are very, very good at doing just that. And from my understanding, the people that are very good at filing deprivation of rights suits under color of law in federal court, they scare the hell out of the cops and out of the district attorneys and out of the counties. They want nothing to do with it because they realize what they're doing. They know what they're doing. It's just when someone has to put them to task for it is the only time that they back off. So, yes, you can do this, and yes, it's possible. I do not under any circumstances put myself out as being any kind of expert in doing deprivations of rights under color of lawsuits, federal suits. However, anyone can become an expert very, very quickly by simply going to the closest federal courthouse. And the clerks at the federal courts are actually very nice, particularly if you're, interested in learning and you're there to study stuff. And you be really nice to them and say, hi, I would just like to do some studying, and I would like to find as many different court cases as you have here in your records regarding people that have filed deprivation of rights under color of law against either state or federal employees. And they'll be happy to give you a ridiculously long list of cases. And then you can either go look them up on the computer and see which ones you like and see which ones, obviously, you want to pick ones that won. You pick you pick 2 or 3 that won. And yes, you do go ahead and get, the full docket and take a look at it. And then you take the suits that they filed, and you plagiarize them as much as you want to. And you use them. And that's what you use. And then you use the whole court docket as a template for what you need to do if you want to take this route. Because people have done it before you, right? There's no reason for you to have to reinvent the wheel here, right? Okay, so federal rules of civil procedure. Another thing for Roman civil law attack, you could do state rules of civil procedure if you're in a state court. And then, as I said, the United States Code, Title 18 for defamation rights and a code of law, that's federal. And the state criminal statutes and state statutes covering due process after arrest, the motor vehicle code, right? All of these things you could use specifically as a Roman civil law attack, right? From the standpoint that you're going to say, hey, wait a second. You arrested me on the side of the road and you threw me directly in jail. Well, hey, wait a second. There's this state law here. And by the way, there is a state law in every single state that states this, that they are required to take you before the nearest and most accessible magistrate for a proper evidentiary hearing as to the reason why they arrested you. They are not allowed in any state to take you and throw you directly in jail and punish you. Sorry, that's not what the law says. And yet all of them do it because it's just policy. No one ever challenges them on it. Well, guess what? You can. And it's right in the state statutes that says that this is what they have to do. So you can sue them in an equity court and say, hey, fuckers, you guys violated the law right off the beginning. You took me directly to jail and you punished me. Okay, that means you lost all jurisdiction from that point onward, because that's what the law says. The law will act retroactively against any officer who exceeds their jurisdiction in the fulfillment of their duties. So if they decide to, steal from you, or if they decide to, some overzealous male cop wants to, rape a woman or something, or they beat the hell out of somebody without any reason for doing so whatsoever, well, then they lose all of the jurisdiction that they would have had to lawfully arrest them from the beginning. Their authority evaporates ab initio. That's the point. So just remember that. So when it comes to state statutes, yes, you can hit them with those too. Okay. And then any and all cases you can find in the court record wherein the counter plaintiff won their suit, meaning you go to the state courts. This would be your district courts, your circuit courts, and ask the circuit court clerks and the district court clerks and say, hey, I'm doing some research and I would like to find and locate cases of which people have sued the state and won for, XYZ, whatever reasons. And that would kind of differ based upon what the state statutes say for your state. But that's how you can do that. So go and then look them up, find them. Okay. And then next resource is copy everything that they did to win, just like I said with the federal cases. From the first motion to the arguments of the Roman civil law is that it's everything quoted in between. So all of it. So you can take a look at the whole case, see everything that they did. And last, but certainly not least, is the law course jurisdictionary, which there's the hyperlink. And this should be able to be copied and pasted into chat. And I highly suggest that everyone get this course. And if you haven't gotten it yet, go get it, because it's definitely worth it. And it'll teach you everything you pretty much need to know about how Roman civil law courts work. And then once you go through jurisdictionary, and this would be the order of which I highly suggest everyone study, because this is the order that I studied in. And it just seemed to make more sense this way. And I see a lot of people getting confused when they don't do this. So I went through all of jurisdictionary, all of it. But I knew it was equity because Bill Thornton had told me, hey, this is all equity now, right? But learn how to do it. So I went through all of the jurisdictionary course. Then I spent several years, well, still spending years, decades, of learning everything that's on 1215.org, everything about the common law, and expanding my knowledge from there about the difference. But you want to learn what their system is first so that you know what they should be and what they should not be doing. And if they're doing something they shouldn't be doing, well, hit them upside their head with it. find whatever state statute says whatever that is. If you're going to do the Roman civil law attack, this option, that's how you go about it. Okay. And then D, this is one so in this section, D, I have some important codes to remember. So 18 USC 1342, fictitious name or address. This is whoever for the purpose of conducting, promoting, or carrying on by means of postal service any scheme or device mentioned in section 1341 of this or any other lawful business uses or assumes or requests to be addressed by any fictitious, false, or assumed title, name, or address, or other name other than his own proper name. Proper name is your first and middle name. Now, yes, you can put House of Doe afterwards if you want, but your proper name is your first and middle name. Okay? Just make a point of that. Or takes or receives from any post office or authorized depository of mail matter, any letter, postal card, package, or any other mail matter address to any such fictitious, false, or title, name, or address, or name other than his own proper name, shall be fined under this title, or imprisoned, not more than 5 years, or both. Okay, what are these private for-profit courts doing every single time that they send you some damn fucking summons in the mail? They are violating 18 USC 1342. Every time. Every single fucking time. Because they are addressing you by a fictitious or false assumed title, name, or and address even. Because technically, you are not under the federal conclave. You're not supposed to be stuck under the Buck Act under a zip code, right? We're not supposed to be there because we're not supposed to be in federal territory. So everything that they're doing is a violation of 18 USC 1342. Just know that. And you can bring this up anytime you want to them and say, hey, why are you sending me stuff that's not my proper name? And then 28 USC 1361, action to compel an officer of the United States to perform his duty. The district court shall have original jurisdiction of any action in the nature of mandamus to compel an officer or employee of the United States or any agency thereof to perform a duty owed to who? The plaintiff. What happened to the defendant? Only the plaintiff matters. You have to make yourself a plaintiff. It's the single most important thing you need to do in any of these options. You really should be making yourself a plaintiff. So you should be on the attack, not on the defense in these. But I just wanted to put this in here for anyone who does go and file. So if you go and file something in federal court, you make it a federal case, and you're saying, hey, deprivation of rights under color of law here, people. And by the way, I'm a plaintiff. If the court clerks like balk at you or whatever when you're filing your paperwork or you're filing a motion, or even if you're filing, say, let's say so I was trying to think of things that the clerk would balk at you for. Okay, so holding somebody in contempt, that's usually one that they're kind of like, oh, you can't do that. Well, yes, you can. And there's even rules under the Federal Rules of Civil Procedure for doing that. Also in the Federal Rules of Civil Procedure, there's also very specific rules for your special master. There's a whole section in the Federal Rules of Civil Procedure regarding how your special master can work and operate, right? And basically what it is on the federal side is that you propose your special master, you appoint them, you put it into the court, and then basically if the other side doesn't object to it, your appointment stands. Now, sometimes I think there is a part of the Federal Rules of Civil Procedure which it states that I think the court can ask the special master, like, what are their credentials, or not give them like an interview, but I think there's something in there about that. But that hardly ever happens. They're just like, oh, this is your special master? Okay, fine. And then you can read all of the powers of a special master and what that entails in the Federal Rules of Civil Procedure. In fact, it's a great thing to just learn those understandings of what a special master is, what they do, what they are for in your court of record, when you wish to have one in your court of record, which is, of course, obviously that's common law, not Roman civil law. But it gives you a good idea when you're reading the Federal Rules of Civil Procedure as to, okay, what is a special master? What can they do? So on and so forth, right? It's basically kind of like a judge without the pay, sort of. But they do have to be neutral. So just remember that. Or they're supposed to be neutral anyway, technically. Even though a lot of times special masters are kind of running things for one side, sort of. but they're supposed to have at least the aura of neutrality for the most part. Okay, last one, Roman civil law defense. Okay, so this is the lowest of the low. So this is the place you never really want to be. All right, so be the defendant in an inferior court, not of record, in equity, using their rules of court and their discovery rules to prove that the state cannot meet statutory requirements because you were not engaged in commerce at the time in question. An example of this would be motions to dismiss for lack of subject matter jurisdiction, motion to dismiss for lack of meeting statutory requirements, meaning you were not, quote unquote, in this state, which would be a improper venue motion. Which, by the way, if you want to listen to someone who did a really good little short snippet on an improper venue motion, Rob Ryder did an improper venue motion short class. I think it was maybe like 30 minutes. Maybe it might have been an hour. But I know on his YouTube site, you can go listen to an improper venue motion. And it's a very interesting thing to do. Now, again, you don't want to really be in this situation of being a defendant in a Roman civil law court. But one of the interesting things you can bring up is that because of this term of art called in this state, where the presumption is that you are in the District of Columbia, one of the things you can do with this improper venue motion is that you could go and get a certified copy of the original land patent from wherever it was that you got pulled over, meaning exactly the place which the cop stopped you on the side of the road. You can go to the BLM and get a certified copy of the original land patent. And then you can put that as an exhibit into, or an admissions of evidence, or exhibit, I guess, into the Roman civil law defense side of the statutory court and say, hey, I'm not in this state. And then they would have to prove somewhere along the lines in that land record that the lands are now somehow subject to the jurisdiction of Congress. And I tell you what, even though we know what they're doing, meaning that they're running through everything through the Torrens registry system, and that the state governors committed treason in 1933 when they had the governors meeting and they pledged all of the quote unquote registered property to the feds to turn around and then give as collateral to a private Khazarian mob international banking cartel called the Federal Reserve. Yes, we all know all this. However, when you're poking them with that kind of stick, they would have to be willing to open up that entire can of worms just to beat your one case. And what we found is that they tend not to want to do that. So just to make a note there that an improper venue motion is also something else you can do there. Okay. And then the other things you can do are also interrogatories, requests for admissions, judicial notices, and other tools of the equity court, all of which you can read in the civil rules of procedure for your state statutes, for your district and circuit courts. Okay. Then resources are pretty much the same as the last ones, but the federal rules of civil procedure if you're in federal court, state rules of civil procedure if you're in state court. Title 18, deprivation of rights under color of law, which we already talked about. That's if you want to make it a federal issue. And statutes covering due process, process after arrest, motor vehicle code, which means they must be in compliance, both state and federal, because I said, as before, all definitions must be in compliance with the USC regarding commercial roadways in the state. And in all cases that you can find in the court record where the counter plaintiff won their suit. Make copies of these, create templates, copy everything that they did to win. And from the first motion to the arguments to the Roman civil law that is quoted and everything in between, as I stated before, and jurisdictionary. And that's also another good point. Inspector brought up the point that the land mass known as the United States is actually on an incorrect and false meridian, which is everything else that they pull it from. And that's a good point, because this whole, and what he's making reference to is what they did when they altered the meridian of which all of the land is supposed to be situated on so that they could literally have this separate, complete land system, which is what the Torrens registry system works off of. Instead of it being under the proper meridian and having proper metes and bounds for your allodial land title, which is what the original land patents should be based on. So just to make a note there. All right. And then, so D, so your import, okay, so C, sorry, your preparation at this, Roman civil law defenses, and this could probably even be more than 3 months, honestly. One could spend their entire life going down the rabbit hole of trying to do what is necessary to try and win in a Roman civil law court. So, I mean, you might as well put an unending amount of time on here, really, because you're never fully done with this kind of study, which is why we shouldn't have to worry about it, because it's foreign to us. Roman civil law is foreign to us as Americans. Always has been, always will be. If you don't believe me, just go read the title of Bouvier's Law Dictionary. And yes, I do just simply read the title. Okay. Then D, important codes to remember, again, 28 USC 1361, the action to compel an officer to make sure that they're supposed to be doing what they're supposed to be doing. This is your way to force the court clerk to file what you're telling them to file. But technically, when you're under a Roman civil law defense, this one you can't even use, because why? Because they only give a shit about the plaintiff. They don't give a fuck about the defendant, right? All right, next one, USC 18. This is 4108. This one is important to bring up when they're trying to force you into their private for-profit court system. And by the way, to make another point about all these court systems are private and for-profit, I made a link to not a link. There's a link to in the mega link. Let's put it this way. In the mega link up top here, I gave a little snippet of a Dun & Bradstreet. What it looks like when you go to Dun & Bradstreet and pull up their Dun & Bradstreet numbers. Now, you have to have an account at Dun & Bradstreet, which basically you can get for free, though. So everybody can pretty much set up a Dun & Bradstreet account for free. So this is one that Phil did years ago, and now Phil's passed on, so this doesn't really matter, but it was Phil that did it. And he did it back in 2017. So anyway, so what we're looking at here, we're looking at Dun & Bradstreet's website. The following is the Dunn's number for now look at this, all capital letters, Judiciary Courts of the State of Iowa. This is their Dunn's number, 051653686. Now, what the hell does that mean? It means that there is, and this differs from state to state, by the way, but the point is that when an entity has a Dunn's number, they are what? They're a fiction of law. They're a private for-profit entity. Well, they don't always have to be for-profit, but the point is that they are a separate fiction of law, right? So the judiciary courts of the state of Iowa are their own creature, their own thing, right? And this is their Dunn's number. So when you want to, you can go and get what's called a Dunn's report, all on the judiciary courts of the state of Iowa, and it'll show you what their bookkeeping is, how much money they bring in, all that kind of shit. Like I said, now sometimes it differs from state to state. Sometimes what you'll get is not all of them being wrapped under one Dunn's number, which is, truth be told, I think I was the only place I know that they actually do this, but not to say that I'm sure, but it's the only place that I know for sure that the whole state, all of the state courts are wrapped under one Dunn's number. Usually what happens, or what I've seen most of the time happen, is that the state courts will kind of have their own thing, meaning like the district courts, the district courts will have their own Dunn's number, the circuit courts will have their own Dunn's number, the magistrate courts will have their own Dunn's number, the chancery courts will have their own Dunn's number, each county court will have its own Dunn's number, each district attorney will have his or her own Dunn's number, each judge will have their own Dunn's number, and so on and so forth. And a lot of the times when you're looking up Dun & Bradstreet numbers for at least the district attorney, you'll find that it will state that the district attorney is, quote unquote, also traded as, Dane County or, whatever, Smith County, right? It'll be also traded as the county of which they're working for, which goes to show you, aha, great. Also traded as, well, again, you're just this private for-profit thing. So what are they doing? So they're dragging us all into all these private for-profit courts by contract and consent, which is, again, Roman civil law aspect of the presumptions that they're holding above you. So anyway, just wanted to make that point about showing everyone who might not have known that, yes, these courts are private for-profit critters. And this part here, this USC, this 18 USC subsection 4108, this is one of these ones you definitely want to memorize. And it says verification of consent of offender. And it doesn't say defendant, it says offender, to transfer to the United States. Meaning, if you do not consent to the transfer of jurisdiction, they can't keep you in their inferior court system. And yes, this applies to state courts as well. Because again, this goes back to the whole, in this state, quote unquote, aspect of that you're in some sort of federal conclave, some sort of federal territory, right? So I didn't put the whole 18 USC 4108 in here, but I highly suggest going and reading it. It's a very interesting statute, and you can bring it up when you're sitting as a defendant. You can say, objection, Your Honor, I don't consent to the transfer of the United States, or to the United States, sorry. Your Honor, objection, I do not consent to the transfer of jurisdiction to the United States as per 18 USC 4108. You can say it just like that. If there's no consent there, technically they can't move forward. That's really why that's there. It's so that there is a consent given, that it's stated in Roman civil law that you do agree to the consent and the transfer to the United States. Because if you don't consent to the transfer of the federal conclave, well, then you're in common law. You're at law, standing on allodial land, having the protections of the common law. So anyway, there was a man whose name was Bill Faust, who made it a point to teach this to all of his students. And they eventually took him out. They eventually killed him. A quote-unquote car accident, I believe, was how they took out Bill. But he was having a lot of people go in and just argue just this one thing. Be like, I don't consent to the transfer of jurisdiction. And the judge would be like, well, what part of the USC, are you talking about? 18 USC 4108, Your Honor. And they'd kind of have to say, okay, well, we're going to take a recess here. And then they'd go shovel it, off the paperwork and get rid of them because there was no consent. So anyway. All right. So number 5, and this is just other matters in general to consider. So these are other things to just consider when we're talking about possibilities of what we can do here. So rights of American citizens under the Expatriation Act. Now, again, when you do get pulled over, yes, you're going to be stuck in basically one of the two statuses. But this is just something that we need to understand. That we as American citizens, as contemplated in an act concerning the rights of American citizens in foreign states of July 27th, 1868, not subject to statutes, acts, ordinances, and codes. And I put a personal note in here. Add applicable information regarding what the president shall do to assist American citizens, which is listed in that act, by the way. And then there's a hyperlink to the act, too, if you want to go look it up. Now, this is the basis on what we do and what we use in the Vocational Science of Freedom status doc set to say, hey, wait, we're not that, we're this. We're an American citizen, an American capital C citizen. And like I said, also as one of the people of the several states of the Union is another way to put that. But in here, in the Expatriation Act, they clearly make a distinction between American citizens and citizens of the United States. They are two different, separate things. So, all right, next one, the trustee appointment. So always remember, if you've already done your doc set, you can appoint the de facto minions. You can appoint them as trustees, and as long as you process serve them with certified copies of your VSOF status docs from the public record, or in appropriate persona in open court, as the judge and the attorneys are public trustees, and you can appoint them so under the Powers of Appointment Act of 1951 as trustees of your estate. So they're public trustees as to their duties to uphold and protect the Constitution of the United States of America and the state of which they are a resident or people. And then you can also appoint them as a trustee of your own estate as per the status doc set and say, okay, if you're going to continue to administer my estate, well, guess what? Now I get to do all kinds of things to you, like take power of attorney over you, drag you into arbitration, binding arbitration proceedings, and you even agree to, or they even agree to be subject to court of record proceedings, all by contract, all by administering your estate without your consent. So that's trustee appointment. So number 3, be sure to state in open court that you come before the court as having been found to be living, having come of full age, and as the sole lawfully appointed executor and sole lawful heir of your estate that is named as the res defendant in the court complaint, summons, or paperwork, whatever it was. So that's an important thing to say. Say all that you've come before the court, having been found to be living, come of full age, sole lawfully appointed executor and sole lawful heir of the res defendant estate. You can say it like that, or you can say just of the, and then just state your first, middle, last name, or whatever's the name on the birth certificate is what you should say, because that's the name of the estate. John Henry Doe. Your Honor, I come before the court as executor of John Henry Doe. Is there any objection to what I just stated? Right? You can do it in piecemeal too. You can say, Your Honor, I come before the court as the sole lawful heir of John Henry Doe. Is there any objection to what I just stated? So you can do these things at different times, or you can try and ramble it all off and get it onto the court record before he or she, the judge, starts threatening with you with contempt or some dumb shit. Right? All right. So number 4. So traffic violations, citations, infractions, and related court issues. So it's not commercial. So were you actually driving? No, you were not actually driving. So you weren't. You're not using the roadways as a place of business. B, there's no valid contract, technically, because there's no consideration. Meaning that the original driver's license contract is void from the beginning because why? Because you use Federal Reserve notes, which is, the Jerome Daly case. But little points like this are not ways that you're going to want to stand on like unendingly, meaning that you don't want to base your whole case around the fact that, hey, the driver's license contract was never, was void from the beginning because Federal Reserve notes don't have a consideration. That's that's a difficult route to take when you're just dealing with a traffic ticket. Not to say it's not true, because obviously it is, but you don't want to use that as your sole lawful defense when you're doing these types of things. But you can certainly bring it up. Okay, C, venue not in the state. We already talked about what that is. D, the corporate state is after your state, the defendant, not the living, breathing man, who is one of the people, you. They need you to agree to be trustee of the constructive trust and that they create so that you are then liable for the charges against that estate. And they also have to get you to agree to the transfer of jurisdiction, which is what I said before. And then 5, the whole thing about traffic infractions. Your Honor, do you have a driver's license? Well, if he does, then technically he's subject to the same statutes, acts, ordinances, codes, and regulations, and technically he can't rule on the matter because he's already subjected himself to the same contract, right? So it would be an aspect of conflict of interest, basically. And then 6, have yourself questioned on the stand by someone else, and have your friend or your special counsel or your special master or your next friend, whatever you want, have them ask you 2 questions. 1, do you have a social security number? No. Are you a citizen of the United States? No. This is how Al Beecroft got over 20 people off as far as IRS tax issues. And I think it was more than 20. I think it was more like 35. He would simply put them up on this. And by the way, Al was a former attorney who basically went rogue after he realized the level of criminality that's going on out there. And he basically put everybody up on the stand, every single client, asked them those 2 questions. Every single time the gavel came down, case dismissed, get out of here. Why is that? Well, if you don't have a social security number, which by the way, you don't, the estate does, but you don't. If you state open court, I don't have a social security number, that gets rid of the presumption that you are federal personnel, right? And subject to the jurisdiction of Congress because you're basically an employee. Well, don't have one. That goes out the window. And then, are you a citizen of the United States? No. Now, you don't have to state what you are, but when you're asked in open court like this by someone else who's giving you questions, the other side might try to cross-examine you. They might say, well, if you're not a United States citizen, why are you then a citizen of Mexico? No, I'm one of the people of Wisconsin, I'm one of the people of California. Or I'm an American citizen. You could say that, right? But you only have to answer those types of things if you're asked them on cross. All Al did was he asked those two questions, and basically that was the end of it. Because those are the two main presumptions that stick us under Roman civil law as being subject to the jurisdiction of Congress. Okay, so that is the end of this short little paper. It's only 3 pages. 4. And now I'd like to have anybody give suggestion as to anything else that they'd like to see be put into this document. And you guys can either just type in a chat, or you can unmute yourself and feel free to talk. Or you guys can also, anybody can get back to me later. I can also, you know what, that's probably what I'll do. I'll post it into main chat as well. And in case for anybody that, didn't get to class tonight, I'll post it in main chat as well, and then ask for suggestions as far as what other people would like, or what anyone would like to have added to this to expand out this document. And like I said, this is more or less like the table of contents of this document. I will be expanding out the document itself, obviously, for all the specifics for each one of these. So instead of just giving examples for what you can do with a common law court of record, I'll give a list of every single thing I know that you can do, which is going to be extensive. But that's going to be part of this anyway at some point. But if there's anything else that anybody can think of as far as like categories or subcategories, maybe. I mean, if you want me to do something for grand jury, I suppose I could do that. Okay. That's a good point, Spectre. Okay, so Spectre asked, that's all good defensive position, some offensive. However, is there anything that has worked by way of roadside etiquette? And yes, there is. And in fact, there is a VSOF member who actually just sent me a little ways back, a couple weeks back, I think. He sent me a actual dash cam footage of getting the land pirates to fuck off. And I'll certainly, you know what I'll do? I'll upload it into the mega folder for this class so that you guys can take a look at it. I'll ask him one last time, because I'm pretty sure he gave me permission to go ahead and share it. But I do want to ask him just one last time before I do that, to make sure that it is okay with him, because I will be putting him out there on Front Street for everyone else for all of time. Unless, of course, I take down this video at some point, which I probably won't. So I can definitely put that up. So yeah, okay. So I'll make a note at the bottom here to add that. So we'll make that number 7, and we'll call it roadside defenses. Let me say that. And I'll give it a space, and then we'll let this be a place where it just be a placeholder. Okay, so roadside defenses, and then I'll say how to talk to land pirates. The other thing is that specifically about this, I know that we did do a few classes at least on the VSOF a while back regarding how to talk to, and it's actually a whole subsection. It's how to talk to minions of the corporate state. There's at least 4 of these classes that go back. So at least we've done some already. So I can put that into chat just to, and I guess it's out of demand proper status, and if your court's not of record, is your state citizenship versus United States citizenship. Do you hold title to your car, and then right to travel, what to say to cops. And so, yeah, okay. So that was at least the 4 that we have on there. Now, that's obviously not all of those are specifically to talking about things on the side of the road. But, so, yeah, I will definitely make a list. How to talk to land pirates, what to give them. what not to do, obviously, because you run into some overzealous cops that all I want to do is they just want to fight because they're either psychopaths or they're taking too many steroids or they just believe in the fallacy of authority, whatever. You're going to run into them. So I'll put in things about what not to do, like how to calm down a crazy cop. That'd probably be a good thing to put in here. And what paperwork to give them. That was definitely covered in the right to travel folder binder, which is something that Mumbles put together and actually did a full live class on last year. But yeah, okay. So that's okay. So I'll do that definitely. Okay. Is there anything else? Okay. So Jub said that Mike Brenton-Holt, his Tesla was left alone by Utah State poopers. His Tesla is not registered or insured. He has his status docs done, and he's done some work with the Secretary of State. I believe last time he was pulled over, he was traveling at 106 miles per hour. I don't know if that was actually the gentleman that gave me the video or not. I'll have to double check. But yeah. So yeah, definitely. There's definitely people that are doing what they're doing correctly. And oh yeah, dash cam. That's a good point. Yep. I will actually put that as a specific thing I'll put it under roadside defenses. Be sure to install a dash cam in your car or truck. Okay, that's definitely a good thing to do. Definitely a good thing to do, so that's good. Okay, is there anything else that you guys think should be added as far as to this document? Oh, you know what? I guess there is something else I should put in here, and I should probably actually put it right in the beginning. Well, a trustee appointment. Okay, so it's basically a trustee's appointment. So I just wanted to make sure that the trustee appointment to process serve upon. Okay, so I was going to all right, so under this, I'm going to make a list. So I'm going to make a list of who one should process serve, the status doc sets to. Okay. So that I'll make a list here too. So that makes sure that people get that, even though that's the list of who to serve is technically in the handbills for the VSOF status docs anyway, but, oh, that's right, Jub. Okay. Yeah. I mentioned an arbitrary process where we can ask the state if they have any interest in this given property via the VIN number. Right. So that would be, okay. That would definitely be its own thing. So, okay. So, and what he's talking about is that there's a whole administrative process, and I didn't come up with this. The guys at Rural Law Radio did down in Texas, Eddie Craig and Eddie, and I forget the other guy's names. Eddie and that's horrible. I forgot. There's three of them. There's two guys and a woman. The only one that's coming to my mind right now is Eddie Craig because Eddie's the one that created this particular process that Jub's talking about. So what they did was they sent notice to the state, Secretary of State, and said, hey, do you have any interest in this property? Meaning, the VIN number and the car. And they would do a 3-step process and give them like 120 days. So they do 3 notices. They do a first notice, second notice, a default notice, and then, or a final notice, sorry, and then default, which is basically what your administrative procedure is. And then what you then do is the final notice you have sent by notary presentment to the Secretary of State, which contains all of the other 3 notices that you had served them previously. And then what you do is you get the process, the full entire process done and certified and basically signed off on by a notary presentment and by notary. So then you can take the notary presentment, and if you have to, you can drag the notary along with you as well. And what you do is you then go to a court and you ask for what's called a declaratory judgment. Now, declaratory judgments have no money attached to them, meaning there's no damages in a declaratory judgment. All a declaratory judgment does is it determines the rights between the parties. And this is a really weird thing in law because it really only kind of came around like in the 1940s and 50s. So it's a fairly new thing in law in general. And I really think the reason why they did it or they created it was because they had to give another out to specifically allow us, we the people, to say, hey, look, do you have any interest in this thing or not? Or am I this or am I that or whatnot? And in this case, being the car. And so once you get the whole entire administrative process done, you file for declaratory judgment and you basically just present what had already been presented to the Secretary of State. And then you get a declaratory judgment from a court stating that, guess what? The state of whatever doesn't have any interest in that car. And so you can basically keep that with you in your glove box as kind of like a substitute for the manufacturer's certificate of origin. Now, if you have the manufacturer's certificate of origin, then you have the original title to the car. And obviously, like what Jubb said, that's obviously what Mike Brenholt has. He kept the MCO, manufacturer certificate of origin of his Tesla. So if you hold that, you hold the title. That's it. The state, it's not registered with the state. They have no interest in it, and they have no right to take it whatsoever. That's for damn sure. So that's the whole point of that. So, okay, so I'm thinking about what I need to put down here. So I'll say administrative default process for, okay, administrative notary default process for, or to say against the Secretary of State for any interest in your property. Now, I think, by the way, just talking about this, I think that Eddie Craig from Rural Law Radio, I think Eddie Craig actually sells that process. Now, don't hold me to that because I'm not 100% sure, but I think Eddie Craig actually sells that process. So, yeah. So that's something that we can at least look into. Then I won't have to rewrite the thing again. But I basically explained in a gist what it is anyway. But if he's already got a template for it, then we should someone should just buy one of them, and then we can tweak it to make sure that it fits correctly with everything we're doing with the status doc set. Okay. Okay, you said, do we want to include a process for deregistering your vehicle with the state? Yeah, that is basically what Jubb's talking about, or what that was. Because it's not like it ever is not still registered. I mean, in a certain sense, there is a kind of a way where you can do that. There's a gentleman on here on the VSOF whose name is Silence. And what he did was he transferred registration of his property to his own house. Now, I thought that was interesting, the way he did it. And he had this, he actually got like this really nice leather bound record book for his house. And he transferred the titles to his own house. So that's something else you can kind of do. And I suppose that would probably be number 9, transfer title to your own house. Okay, so transfer title car to your house. I'm just going to put a notice or put a note here to myself. Okay, so there's that. But one of Craig's guys didn't know what I was talking about a year ago. That's weird because that's where I got the idea from. Now, this was a long time ago when I was talking to Eddie Craig about this. This must have been, oh my God, this was probably back in like 99, 2000, something like that. That's how long ago I was talking about that. But I was pretty sure he had a process. I can look to see if I don't still have it, because I do have a folder for Eddie Craig, and it might just simply be in there. But I'll have to look. But anyway, this will be one of the one of the reminders in here for me to go looking for it. Okay. So, yeah, exactly, Spectre. The guys over at Davos who think we'll own nothing and be happy about it. Well, guess what? That whole entire system is already in full force and effect, guys. It's not like they have to create something new for that to happen. That is what the system is right now. Everything that you have registered is exactly what the global homos are trying to do. They're saying, oh, you won't own anything, but you'll be happy. Well, you already don't own anything if you've already registered it all with the fucking corporate state anyway. Therein lies the problem. We got to get everything out of the corporate state. Absolute freedom of property. Remember the short snippet that I took from, I can't remember the name of the gentleman's name, when I did the declaration, the reading of the Declaration of Independence last time, or a while back. It was a few weeks back. The gentleman who was talking, the snippet, the audio snippet that I took from that class, when the gentleman is talking about absolute property rights under natural law, and that when that is complete, that the American Revolution will be complete. That's a very, very important point. Okay. And that's exactly what we're getting at. In case anybody doesn't or hasn't watched that or listened to that, you can just go to the VSOF Odysee page, which is odysee.com/@VSOF:8. And then just go to the Declaration of Independence and listen to that one, because there's a couple snippets in there of some gentlemen that are talking about the Declaration of Independence. And one of them makes that specific point, that once the totality of rights and property is complete, that then the American Revolution will be complete. And that's exactly what we're talking about. It's about keeping our property, what's ours is ours, render under Caesar that which is Caesar's, and render under God that which is God's. That's the point. Number said, what about what if the auto loan is charged off to a third-party collection, but you still have the vehicle? How would one go about a scenario of getting the title? That's a problem with contract. So, yeah, that's a whole issue with a contract issue regarding a loan, because I don't think I want to start crossing the lines or starting to get into stuff about property that we do not actually own yet, meaning that there's a whole set of law merchant garbage with loans and banking stuff and whatever else. So I don't think I want to go down that route with this learning handout. So this learning handout is only going to be dealing with something that you do own outright, with nothing with loans in it. Let's put it that way. So, because otherwise, the manufacturer's certificate of origin has already been faxed to the state. The vehicle has been registered with the state. The bank holds, quote unquote, the title, but only the title of usufruct. So technically they can come get it anytime they want to. And obviously so can the repo man because of that system. So yeah, there's too much stickiness there to worry about. Okay. Anything else? You guys want to add? Somebody is recommending the means to get a new MCO on bond paper. Now there's only one MCO that I know of. Oh wait, no, sorry. Take that back. That's a good point. My friend TJ Henderson, he did look into the MCO, of getting another MCO, but he said the only company apparently that will hold the MCO like indefinitely is Dodge. Now, why does that not surprise me? But so I'd have to ask him, but I think what he did was, I think he might have contacted Dodge and actually gotten his. But I'll have to ask him about it. So, MCOtitles.com apparently has a proprietary process that catches once you have the new MCO on bond paper. It can never be registered again. Yeah, exactly. Record the new MCO with your certificate title as a complete superior title. Well, I would record the new MCO with your certificate of title onto your private house records, and then take a copy of your private house records and then record that onto the public record. That's what Silence did, which makes more sense. So in a sense, he kind of did what this MCOtitles.com is kind of doing. He already did it, pretense to it. But yeah, if we can look that up, I mean, I suppose I can just put that in here as something to look at and see what they're up to. But we certainly don't need to do anything they're doing. We can do it all ourselves. So titles, C-O-T-T-I-L-E, titles.com. All right. Okay. Yeah, Ford destroys theirs in 7 years. And I think a lot of others do too. I don't know about Tesla. We'd have to look up Tesla. I have no idea. But yeah, I have seen the original Dodge Brothers logo, Janice. I'd first seen it. Somebody posted it in main chat. Yeah, it's a bunch of Jews. The Dodge Brothers sued Ford for, and this is all in main chat. I'm not trying to digress here, but it is still along the lines of being on topic here. The Dodge Brothers sued Ford because Ford was going to give a whole bunch of bonuses to their employees and something else too. And the Dodge Brothers sued Ford to say, you can't do that because why, I don't know, but that was the gist of the suit, saying that they owed allegiance to the shareholders. I think that's what it was, because the Dodge Brothers held what, 10% of Ford or 15%? 10%. Yeah, okay, that's what I thought. Yeah. So, yeah, that whole fucking bullshit, but it makes perfect fucking sense that they were Jews. I mean, my God. Right on money. Oh, you can't do that. That takes away our profit. Yeah, you can't do something nice. And now, that's precedent now for how corporations are supposed to act when it comes to the difference between, their shareholders and what's deemed to be good and proper in a society. It was because of two Jews called the Dodge Brothers that sued Ford about it. Yeah, no surprise there. Spectre said John Deere was sued a few years back regarding ownership of farm equipment, in that farmers could only have work done on machines because of the proprietary software on said machines that could not be messed with by third parties. Court revealed that John Deere technically owns the equipment, but you are a renter of the equipment. Yeah. Yeah, exactly. Same bullshit. I mean, that's the same thing that's with all the cars. I mean, every single thing that's registered. Now, the thing about a proprietary software, I don't know about that. Well, that's kind of pushing it, but I get the point. This is just attorneys, this is just Khazarian mob doing Khazarian mob shit. Okay. So with that, we're an hour and 45 minutes. This is a really long session. I hope the audio was great tonight. I hope that getting this new bike helps tremendously. I hope that the broadcast was good, the live stream was good, and that nobody had to turn me up anymore, hopefully. And I hope that the recording stays good, and I'll repost it or put it up as soon as we get done. So thanks everybody for coming. And if you found information to be informative and good and you learned something, then please make sure to like and subscribe to the Vocational Science Freedom YouTube page and the Odysee, and join the Gilded server to be part of the community. And until next time, hope you enjoy all the rest of you guys' weekend that you have left. And we will have class on next Wednesday, for our year in review of 2022. And I want all you guys to come with every single idea and thought and feeling that you had about 2022 next Wednesday for the Vocational Science Freedom Open Roundtable. So until then, thanks a lot, and stay safe and stay sovereign.